In case 08205, Citizens United versus the FEC, Justice Kennedy has the opinion of the court.
Imagine for a moment you are Chief Justice Clarence Thomas, hereinafter referred to as Justice Thomas, assigned as one of 9 U.S. Supreme Court authorities residing over the Citizens United via Federal Elections Commission 2010 case. One cannot help but wonder what went through the mind of Justice Thomas the day of the final 5-4 ruling. And what exactly does a partial dissent decision look like? Justice Thomas faced ruling over the subject matter of allowing a political action committee to operate with the same constitutional privilege as a U.S. citizen. Little do the American people know these committees can receive unlimited advertising funding and qualify them for protections of actual voting citizens, and their same protections under the First Amendment. I know it sounds far-fetched, right? I know I asked. This whole corporate citizenship stuff has me wondering, how so? Like, how so? The subject matter discussed in this presentation refers to a slang term called super PAC, also known as corporate citizen. Just exactly what does that mean, and what does Justice Thomas have to do with any of this, right? Well, simple. As one of the 5 who ruled in favor of overturning campaign laws that now benefit corporations during elections and their advertising agendas, Justice Thomas split one of the 5 decisions down the middle in the form of a partial dissent. Before we unpack this order of business, first we must define what exactly is a political action committee, referring to this case. And in this case, the petitioner seeks overturning precedent that would allow corporations to receive the same protections as voting citizens. Along with unpacking the terminology, I'd like to share with you a short case brief that invite viewers to continue the story in the description.
That planned to broadcast a film in the year 2008, which was a presidential election year. The film was entitled Hillary the Movie. The film was a commentary on the career and background of then Senator Hillary Clinton, who was a candidate in the presidential primaries. The case came before us on appeal, and it was argued last term. This court ordered re-argument to address whether the court should overrule either or both Austin and that part of McConnell which addresses the facial validity of Section 441B. And our opinion is announced in this session today pursuant to the statute that directs us to expedite constitutional challenges to BICRA and the disposition of those challenges. In addition to the difficulties of interpreting the statute in these ways, the time, expense, and uncertainty involved in case-by-case determination to elaborate as applied exceptions would chill political speech.
So, Citizens United represents the loopholing of the U.S. Constitution as expressed by the parties who read the final ruling. You're probably confused like most Americans. Who in their right mind would agree to this Supreme Court transaction? Justice Thomas did. Thomas saw nothing wrong with allowing corporations to have free speech. As a conservative, that's what Thomas was looking into, was upholding free speech in the Constitution. So the Conservative Party pushed the envelope by exposing then Hillary Clinton's campaign in 2008 running for president, and that through the First Amendment, Hillary was to be televised on multiple mediums. Citizens United fought to make it so. Justice Thomas was one of the 5 who approved overturning of a previous 1978 case that bound corporations from acting as citizens, specifically during elections. Corporate citizens now have emerged with unlimited opportunity to retaliate against those who oppose organizational values, including on the big screen, which happened in the movie Hillary that launched unknowns about conservative opposition during the 2008 election. From a balanced perspective in law, the outcome would first require a case brief to sort through exactly what Justice Thomas got into that day and his decision pending. The Chief Justice could not call in sick that day. The subject matter in this case and why Justice Thomas ruled in favor recognized that nothing shall come before free speech, which Justice Thomas made clear in his partial dissent could happen in the form of chilling political speech. In this case, chilling speech referred to precedent for those who identify as corporations or unions and their ability to reach and influence voters. The U.S. Supreme Court was determined as the proper venue in this case, and First Amendment protections were the jurisdiction. One could safely assume taking up the issue of chilling political speech brought Justice Thomas into carefully planning a dissent because Justice Thomas politically identified as a conservative. Conservatives hold Federalist allegiance to preserving the Constitution on all levels.
It prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. Austin and its rationale, however, would allow the government to ban corporations from expressing political views through any media, including media beyond those presented here, and in this case, such as by printing books. Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual.
Citizens United is a wealthy, nonprofit corporation that runs a political action committee, or PAC, with millions of dollars in assets. Under BICRA, it could have used those assets to televise and promote Hillary the movie wherever and whenever it wanted to.
Is a PAC, you ask? A PAC, right? That's a complicated subject loaded with several cases that once upon a time regulated corporate and union campaign spending that no longer exists. First off, PACs rob America of democracy's intended purpose, according to author Joseph Christopher Jr., who states 60% of Americans do not know the purpose or existence of super PACs. Well, I'm here today to educate you. Christopher's Revive True Democracy, Minimizing the Effects of Super PACs in the Election Process, defines the term PAC as an abbreviation for Political Action Committee. The author's article dives further into the term, stating PACs run and spend money to support political candidates who do share similar ideological views or oppose the election of candidates whose views are contrary to the PAC. Candidates in turn use these contributions to help their campaigns reach more voters in the quest of elections through commercial advertisements. So basically, a Machiavellianese, which speaks the language of conspiracy and bad faith, acting as the agency under Governor Tony Evers, then the Madison-Normal Bridge campaign.
As Aristotle recognized in the Poetics, the identity and the incentive of a speaker are always relevant when evaluating his speech, and indeed it is that insight that motivates the disclaimer and disclosure provisions that the court upholds today. The court's premise is particularly misguided when it is the identity of corporations that is at issue. Simply put, corporations are not human beings. In the context of an election to public office, the distinction between corporate and human speakers is significant. Corporations cannot vote or run for office. Because they may be managed and controlled by non-residents, their interests may conflict in fundamental ways with the interests of eligible voters. So-called quid pro quo corruption and the appearance of such corruption. In my judgment, this crabbed approach disregards our constitutional history and the functional demands of a democratic society. On numerous occasions, we have recognized Congress' legitimate interest in preventing the money that is spent on elections from exerting undue influence on an office holder's judgment and creating the appearance of such influence beyond the sphere of quid quo pro relationship.
2010 became the turning point, and the decision came down to one Chief Justice's opinion regarding how banks and laws must adhere in the future elections to corporate election protected speech. Now, from the case brief perspective, the evolution of the case began with First National Bank of Boston versus Bilotti in 1978 that Citizens United reflected upon and was part of the precedent in the ruling of the case. That case limited corporate free speech and spending on advertisements for elections. In another case, in Bilotti, the court invalidated a Massachusetts statute prohibiting corporate expenditures on ballot initiatives, holding that the First Amendment does not depend on the corporate nature of the speech. The decision established that corporations and collective entities may engage fully in public discourse. Building upon Bilotti, Citizens United struck down Federal Statute 441B of the Federal Election Campaign Act, which barred corporations and unions from making independent political expenditures. The court concluded that such restrictions amounted to unconstitutional censorship, emphasizing that the First Amendment protects speech, not quality of influence. Justice Thomas' concurrence warned that disclosure requirements could invite retaliation, highlighting the tension between transparency and free expression. Later, McCutcheon versus FEC in 2014 expanded on Citizens United by invalidating aggregate limits on individual campaign contributions, as read. The two cases ruled on the findings from Citizens United, reasoned that preventing corruption cannot justify unnecessary restraints on speech. That corruption itself is not a reason that corruption can continue in a democracy. Together, these cases form the foundation of modern political speech doctrine. The government may not suppress expression based on the identity or structure of the speaker. For instance, if students at Madison College formed a political action committee, and did, called Fist of Senate Incorporated, this political action committee could use the campus radio station to discuss controversial topics, and the college could not silence them, echoing the protections affirmed in Bellotti and Citizens United. So the question is, do you agree with this court's ruling? What is your constitutional reasoning?
The difference between selling a vote and selling access is a matter of degree, not kind, and selling access is not qualitatively different from giving special preference to those who spent money on one's behalf. Corruption operates along a spectrum, and the majority's